Hi, everyone. My name is Beth Wright. I am a staff attorney at the Native American Rights Fund in Boulder, Colorado. NARF is a large nonprofit Indian law firm that focuses on upholding tribal sovereignty and a lot of other issues that face Native American communities. Today, I'll be talking about the Indian Child Welfare Act. So thank you for having me. You can go to next slide. Next slide, please. So I apologize, Erin couldn't join us, so it'll just be me chatting about ICWA today. So if you don't know about ICWA, ICWA is a federal law that was passed in 1978 to address alarmingly high rates of removal of Indian children from their homes and families and communities by federal, state, public, and private child welfare agencies. And so what NARF has done over the years is been involved in protecting ICWA and strengthening ICWA at all levels. So these are just some of the examples of what the Native American Rights Fund does to protect ICWA and strengthen ICWA. One of our most popular legal guides is the Practical Guide to the Indian Child Welfare Act, where practitioners in ICWA related cases can come to this guide and just understand a little bit more how ICWA is applied in state court. And we're involved in various federal challenges to ICWA, as well as providing hands-on assistance for tribes who are working in state custody proceedings. Next slide, please. So, as I mentioned a little bit about ICWA, ICWA is a law that was passed in 1978, and it sets minimum standards in state court proceedings to ensure that Indian children's best interests are protected in foster care, adoption, and termination of parental rights proceedings. And so ICWA is a law that is applied in state court and is and has been challenged at the federal level on several occasions. These two are the most prominent challenges up until the most recent challenge we saw in November of this year. But these are two cases just giving examples of how federal courts have interpreted ICWA, and it's been very rare. Next slide, please. So ICWA has been updated only twice. In 2015, the Department of Interior issued guidelines on how ICWA is to be applied expressly in state court. And then in 2016, these regulations associated with the statute itself were promulgated, and these came from thousands of comments from tribes, states, and child welfare agencies, specifically addressing discrepancies in how the statute was applied. And so ICWA has, has several provisions. Two of the provisions that are most popular and well-known are ICWA's Indian child definition. And so Indian child, as defined by the law, is a member or a citizen of an Indian tribe and a a person who is eligible for membership or citizenship in an Indian tribe and is the biological child of a member or citizenship of an Indian tribe. And so that's how ICWA classifies who is eligible for ICWA's protections. Is if you're an Indian child or eligible for membership, if you meet that definition, then you fall within ICWA's protections. And so these guidelines and regulations helped clarify that understanding and a number of other understandings within the law. Next slide, please. And so as we've seen ICWA's regulations challenged more and more, we've seen what we consider a coordinated attack on ICWA. We've seen federal cases pop up in a multitude of states challenging similar provisions of ICWA. They've challenged that Indian child definition and ICWA's placement preferences. So what's also well known about ICWA is its placement preferences. And so what happens is if there's an Indian child in need of an adopted placement, ICWA states that in absence of good cause to the contrary, a child shall be placed with first a member of the child's extended family, second with other members of the Indian child's tribe, and third with other Indian families. And so it's those three placement preferences that we see are being challenged along with that Indian child definition. And those challenges come from all over the country, but we see the same arguments come up again and again to those placement preferences and that Indian child definition. And what's rooted in ICWA is the idea that children do better when they are placed with those who know them and love them and who can provide a connection to their community. And that's not just true of Indian children, that's true of all children. All children do better when they're placed within their community, and that's what ICWA tries to capture. But unfortunately, as we see here, we see challenges to how ICWA tries to ensure that children maintain connections to their communities. Next slide, please. You might. So when we talk about the Indian Child Welfare Act and the challenges to it, this has been the case that came before the Supreme Court in November of 2022 was the largest attack on ICWA that we've seen. And we saw it come up through the district court and, end up in the Supreme Court. And that's a little bit of what this background is here. Next slide, please. Next slide. And so this was the lower court decision in what we know as Holland v. Brackeen, or the Brackeen case that was heard at the Supreme Court. And I won't go too much into detail, but this is just a little bit of the background on the arguments that were made in front of the court, the lower court in this case. Next slide. And so this case, after it was heard at the lower court, it went up to the Fifth Circuit on appeal. And this case was one of the the opinion that was issued in this case was a pretty much a win for the pro-ICWA side. And as you can see, there was a ton of amici who came to the table to show their support for ICWA. And it was 325 tribes and 557 tribal organizations and multiple members of Congress, multiple institutions that promote the health and well-being of children that came to the table to say ICWA is a law that we believe protects Indian children and uplifts and supports Indian families and Indian communities. And so we saw this really large effort come together at this stage to to show support for ICWA. Next slide. And so the Fifth Circuit issued its decision on August 9th, 2019, and the tribes and the federal government won on this side. And then unfortunately, the case went en banc at the Fifth Circuit. Next slide, please. And so this means that when a case goes en banc, then the court has agreed to rehear the case because there are issues of great importance that the court would like to hear more about, essentially. And so the Fifth Circuit reheard the case en banc. Next slide. And again, when the court heard this case en banc, even more tribes and more tribal organizations and more entities came forward to show their support for ICWA. It was now 486 tribes who showed their support for ICWA at this stage, and more members of Congress and more states and argue how important ICWA is to tribal nations. Next slide. And so what happened in this case is there was a 315-page opinion that was issued by the en banc court. And this is an incredibly large opinion. It took days for attorneys to delve into and understand the holdings of this case and this opinion. But essentially, it was another win for the tribes. The court found that Congress does have the authority to enact ICWA, and many of the provisions that had been challenged at lower federal courts and had been challenged at the lower court were upheld as constitutional. Next slide, please. This is just a little bit of the breakdown of what was upheld in the en banc decision and what was a lot of provisions that were upheld, but there is unfortunately still a split on what's constitutional and what's not. So this is a case that is definitely ripe for the Supreme Court to review. Next slide. And this just talks about how that en banc decision was applicable in courts, and it wasn't applicable all over the United States, just in these limited scenarios. And so, this sort of says why it was strange that this case is going up on appeal so strongly. Next slide. So these are the arguments that were presented to the court. There were 4 main arguments. It's how we classify arguments. There was a lot of different arguments that were presented, but essentially we break it down to the fact that ICWA is that the arguments brought in front of the court were that ICWA is beyond the scope of the Indian Commerce Clause, that ICWA violates anti-commandeering, that ICWA violates non-delegation, and that ICWA violates equal protection. And so those arguments are the core at what was presented to the court by the interests that were opposed to ICWA. And so those were the arguments that the tribes and the tribal interests had to defend against. Next slide, please. And so this is a little bit about the timeline last year when the Supreme Court agreed to hear the challenge to ICWA, hear the Brackeen case in November of 2022. It took months and months and months of preparation in order to have a united front to come out in support of ICWA. And this is a little bit of the timeline that the parties had to abide by in order to get their arguments in before the court. Next slide. And so these are those interests that came out in support of the anti-ICWA side. When we talk about amici, those are non-parties who are allowed to submit briefs before the court to show their support for a side, either the plaintiff or the defendant. And so there's several amici that came in support of the anti-ICWA side, but not nearly as much who came in support of the pro-ICWA side. Next slide, please. And so this is a little bit about the brief that my law firm wrote. We wrote a brief on behalf of the tribal nations and tribal orgs in support of ICWA. This is the largest coalition of tribes, I believe, that came together to show their support on an amicus brief. It was 497. We submitted a brief like this at the district court and both Fifth Circuit Court hearings. And then at the Supreme Court, we had even more tribes that had signed on to any of those lower court briefs. And this just shows how united Indian country was in their support of this law. Next slide, please. And so this is another brief that came out in support of ICWA. This is the state's brief that came out in support of ICWA. As you can see, there was 23 states and the District of Columbia that signed on to this brief, which highlights how important ICWA is to states. As I said, ICWA is ICWA is applied in state court, and the 23 states that came out in support of ICWA were all bipartisan states. So it wasn't just Republican states or what we think of Democratic states. It was 23 states on all spectrums who were showing their support for ICWA. Next slide, please. This is just another example of who came out in support of ICWA. 87 members of Congress. Los Angeles County, who has the largest American Indian and Alaska Native population in the United States, came out in support of ICWA. Next slide. And another brief that was really important was the Child Welfare and Adoption Organizations brief. And so this is a network of 26 of the nation's most well-respected child welfare, adoption, foster care, and social work organizations. And this brief was frequently cited during oral argument in front of the Supreme Court, showing who are the experts in child welfare and children's rights and the rights of families, and why do they think ICWA is such an important law and should be upheld. Next slide, please. Again, this is more briefs in support of ICWA, just showing how extensive the support was for ICWA. Next slide, please. More support for ICWA, the doctors and psychologists in support of ICWA. Next slide, please. There were these incredible briefs that were written from former foster children, from parents who were non-Native who adopted Native children, and grandparents who had adopted Native children on behalf of their families. And so these briefs really told the story of ICWA from a lived experience and what it means to maintain that connection between the tribe and the child, and how important that connection is. Next slide, please. And this was just a little bit more about the experts. There were many scholars and historians who talked about the history of Congress's power to pass ICWA and the constitutionality behind ICWA and why, ICWA is an appropriate exercise of Congress's power. And so these briefs were really important in highlighting those arguments. Next slide, please. A little bit more about the briefs. Next slide. Next slide, please. We've got a lot of briefs here. And so what happened was that the court heard the argument on November 9th of 2022, and we're expecting that decision any day now. We thought it was going to be last week, actually, and so we were, frantically checking our phones and checking the Supreme Court blog to see if anything came out, but essentially the decision could be issued any day now. Next slide, please. And so people often talk about, how do I protect ICWA? And one thing that we are doing in the meantime, while we're waiting for the Supreme Court to issue their decision, is we are, building state ICWAs. State ICWAs are the only solution to the what kind of decision the court could come down with, but these help build what a state ICWA looks like in a specific community. So many tribes are found in these states, and there are high amounts of Indian children within these states, and so it was vital that these states pass their own state ICWA that has more protections than the federal ICWA. The federal ICWA just sets minimum standards for state courts, but when you build a state ICWA, you can really go to the tribes in the community and say, what do we need to protect our Indian children here in our state? What does it look like to maintain a connection between the Indian children and the tribes in these states? And so these are some examples of the states that have developed those state ICWAs. Some of them have just incorporated some of the federal law into state law, but some of them have really deepened ICWA's protections. So New Mexico is a big example of that. New Mexico has a state ICWA that goes above and beyond the federal ICWA, and it does a number of things, but one of the things that we like to highlight is that it ensures that there are cultural compacts made between an adoptive family and the tribe to ensure that the Indian child or children who are adopted or in foster care can maintain that connection to the tribe in a really respected way, and in a way that is mandated by the tribe and is goes a little bit deeper than just what the federal ICWA provides for. And so we're working to develop those state ICWAs in many different states. Colorado was one of the most recent states to pass a state ICWA, and North Dakota has recently followed as well. And so while state ICWAs are important, it's not just a state ICWA that will ensure that Indian children receive the best protection possible when they're in those child custody proceedings. As I talked about earlier, there were 4 arguments that went before the Supreme Court. And, when we talk about how the court could issue a decision, the court could do many things. The court could issue a decision that strikes ICWA in whole, or it could strike ICWA in part. And so the only way we won't really tell, we can't really tell what's going to happen. We just can do our best now to protect protect Indian children by, creating these state ICWAs and building up child welfare, tribal child welfare programs as well. So, we have those 4 arguments that are being brought in front of the courts, but the only way to truly protect Indian children is keeping them out of these state custody proceedings, and what that looks like is sort of up in the air, but tribes have always protected their children, and so they will continue to do so. I think the scariest argument is that equal protection argument. And so the equal protection argument is that ICWA violates equal protection on its face. And it means that tribes will, if the court accepts that argument, it means that tribes will no longer be able to maintain their sovereignty in a way that they have always maintained their sovereignty, because that argument goes to the heart of what it means to be Indian in the United States. And because tribes typically enjoy that government to government relationship with the United States, that means that being Indian in the United States is a political classification, not a racial classification. And so if ICWA is struck down as violating equal protection or being race-based, then we could see these state ICWA fall. We could see more of the laws that Congress has enacted to protect other aspects of tribes. So, tribal education or healthcare or tribal natural resources, we could see those fall as well. But right now we don't know how the court's going to rule.
Hello, Beth, are you still connected? One moment, everyone, while we try to get Beth reconnected.
I apologize, everyone, for that. I'm not sure what happened there. I'll just get back to where I was, talking about the state ICWAs and their importance, and what we're thinking of as far as next step goes. As I said before, we don't know how the Supreme Court is going to rule, but what's most important is that we are working to strengthen ICWA and imagine what's better than ICWA. And so I think some of these state ICWAs have done that by saying, what do Indian children need in our states, and how can we protect them in our states outside of the federal law, other states are thinking past state ICWAs altogether. It's ensuring that tribes have more resources to strengthen their own child welfare programs within the tribe itself. So the state isn't even involved at any level. And so we're exploring all of those options. And another way that's important to protect ICWA is just by sharing what ICWA is. A lot of folks don't know what ICWA is, or don't know what what happens at the Supreme Court this last November. So we are, trying to build public knowledge of ICWA and tell folks why it's so important. Next slide, please. These are just some of the options that I mentioned earlier. I think building tribal systems is one of the most important. It's ensuring that children aren't in the state child welfare system at all. It's strengthening Indian families, strengthening Indian communities, so Indian children aren't placed up for foster care or removed from their families. It's a lot. It looks like a lot of things, but it's one of the most important ways that we protect Indian children. Next slide, please. And so I know I was cut out for a while, so I apologize for that, but I'm happy to answer any questions if there are any questions in the chat, or if any folks have any questions.
So Beth, we have one in the chat. Can you provide scripted messages or links to promote ICWA awareness?
Yeah, that's a really good question. Thank you for that question. If you go to Protect ICWA, then there is, and I can add that in the chat when I get a second, but Protect ICWA is our campaign that we designed to raise awareness for ICWA. And in there's a lot of messaging that can be shared. There's a lot of links to stories about how ICWA is applied in day-to-day cases, stories from those who have experienced life with ICWA and without ICWA. And so it's the Protect ICWA link that I can share in the chat. That would be the best place to go for that type of information. Oh, I see Casey just added that to the chat. So that's the best link.
If there are any other questions, y'all are welcome to put them in the chat or in the Q&A section. Okay, so we have another question in the chat. Where can we find out when the Supreme Court reaches a decision?
That's a really good question. Usually SCOTUS blog is one of the best places to go to see when the court issues decisions. You can also go to narf.org, narf.org, to see any updates about the case. And we will be posting a synopsis of the case and just updates on, what attorneys who have read the case and digested the case think of the case and the decision. So both of those would be places that you could see what the Supreme Court has ruled and a more nuanced discussion of what the Supreme Court's ruling means.
And I did put those links in the chat, so if y'all are interested in checking either of those things out, those are in the chat as well. Okay, we have another question in the chat from Doug. What do you suggest in terms of reaching out to officials in our different states to see about ICWA status?
That's another good question. There's a link on Turtle Talk, which will show every state that has enacted a state ICWA. And then it's just important to reach out to your representatives to ask them if they're in conversations about state ICWAs, what a state ICWA would look like in your state. State ICWAs often do best when they are led by the tribes that are in the state, tribes or tribe. And so, Arizona hasn't quite moved on a state ICWA because the tribes are still working on what that would look like best in their state. So I think all of those types of conversations are important to have. And just the most important would be, just checking to see if your state has a state ICWA, and then asking, if not, who are the folks who would be the state representatives or anything like that, or state experts who would be those who are drafting the state ICWA bill, or poised to start drafting the state ICWA bill.
Right, and then there's another question. How does this case impact other areas of tribal sovereignty?
Oh, I apologize. That's a good question. So that's that. The equal protection argument is what I said was probably the scariest argument that we saw in the challenge to the case. And so that argument is essentially saying that, Indian status is no longer based on a political relationship between the United States and the tribes. It's a racial status. And so it's reducing the tribal sovereignty that's inherent, that was built on the government to government relationship between the tribes and the federal government, to only a racial status. And so tribes, exercise their sovereignty in a variety of ways. And so the impact there would be great, because ICWA was passed on this idea that that tribes are those separate sovereigns, and that's something that's rooted in a lot of Indian law, and Congress's power to legislate on behalf of tribes is partially rooted in the tribe's inherent sovereignty. And so what we have is called Title 25, and that's a chapter of the United States Code that details a lot of different Indian statutes related to Indians and their health and their education and their natural resources. And so if ICWA is unconstitutional on equal protection grounds, it's likely that ICWA, those other statutes related to Indians are also unconstitutional. So we could see a lot of other Indian law fall, and a lot of other protections fall as well.
Okay, and then another question in the chat. This case is being pushed with a lot of political and conservative support. If the Supreme Court rules in tribal favor, will they be able to continue to challenge ICWA?
That's a good question. I think, unfortunately, we won't stop seeing challenges to ICWA. I think there's already a case that was brought up through Minnesota that had a similar challenge to ICWA, but with a different set of facts. So cases are often brought on the best facts. And so if there's a case that has better facts than this, there's a chance that, those better facts will be a better vehicle for challenging ICWA. But one thing we're also seeing is these same arguments that are brought in the ICWA challenge are being brought in other challenges to other Indian statutes. And so a big one is Indian gaming. I believe there is a case right now that essentially it's the same 4 arguments that were brought against ICWA, but are brought against the Indian gaming statutes. And so we're seeing that it's not necessarily an attack against ICWA, but it's an attack against tribal sovereignty, and those arguments that attack the core of tribal sovereignty will unfortunately probably be brought up again and again. If there's no more questions, I'm also happy to answer questions via email. right@narf.org is a good email to reach me at. So I'm happy to answer any questions there as well.
I put her email in the chat if y'all do think of a question that you would like to email her. Otherwise, we will stay on for a few minutes if there are any other questions that you think of. Oh, okay, there's a question in Q&A. So do you think the case was really to help weaken Title 25?
I think there's always a chance in that. I think, because as I said before, we've seen so many of the same arguments brought again and again to different statutes, different laws related to Indians. I think that there are those interests out there that are interested in attacking tribal sovereignty and diminishing tribal sovereignty. And that looks like an attack on the root of the powers that allow for Title 25 statutes to be enacted. So.
Awesome. Thank you so much, Beth, for your presentation today. Thank you all for joining. Like I said, we will stay on for a few minutes in case anyone else thinks of any questions. You're welcome to stay in the room or share those questions in the chat or the Q&A. Otherwise, the next thing that's going to be happening is the first networking session of matchmaking, which you can go to through the courtyard. So feel free to join the matchmaking session. You can stay on and ask any remaining questions that you have. Otherwise, thank you so much for joining us today and have a great rest of your day. Matchmaking starts at 3:35 Eastern Time.